Welcome to this review of the Search and Surveillance Act 2012. The Act has been in force for less than 5 years, and that might not seem like a very long time in which to assess how such a large piece of legislation, which interacts with over 70 other pieces of legislation, is working. But the passage of this legislation into law, which began in 2007, created real anxiety. That is understandable. The words search and surveillance carry their own special power in this digital day and age, and in the face of fast developing technology. So Parliament built a review trigger into the legislation to ensure that this review would happen at this time. There are two bodies involved in this review. One is the New Zealand Law Commission, which is our permanent independent law reform body, and the other is the Ministry of Justice. And together for the past 5 months, we've been talking to agencies and people who interact with this legislation on a daily basis. For the most part, the legislation appears to be working well, but we have identified some areas where we think there is potential benefit from amendment. In the issues paper we've published today, we describe those areas where we see some potential for change, and we ask some questions. And we want to know your thoughts on how the Act is operating and whether any changes are needed. The Search and Surveillance Act aims to balance human rights values and law enforcement needs. The debate when the Act was created suggested that New Zealanders generally want to be free from unjustified state intrusion into their lives, in the sense of being observed or listened to or otherwise monitored. At the same time, New Zealanders want a society that is safe, which means our legal system needs sufficient tools to be able to detect and investigate crime and to enforce the law. The Act seeks to reflect both of those desires. It provides powers for law enforcement agencies in defined circumstances. It regulates how those powers are to be exercised, and it provides measures to hold agencies accountable for their use. The Search and Surveillance Act controls to varying degrees the activities of a wide variety of law enforcement agencies, and there are a lot of them. Some will immediately spring to mind. For example, the police and the detection of criminal offending, customs, and the prevention of smuggling, inland revenue, and the curbing of tax evasion. But the Act also applies to the inspection and search activities of agencies who enforce more than 70 widely varying acts. So, for example, the Act can apply to the work of animal welfare inspectors, or fisheries officers, or product safety officers, or food officers, forestry officers, gambling inspectors, immigration officers, and wildlife rangers. Our issues paper discusses a number of areas for possible improvement. Many of those stem from the rapid advance of technology, which has changed to some degree the context in which law enforcement agencies are operating. There's an ever-expanding range of technology which is available both to criminals in terms of its use in their offending or to avoid detection, and to the police in terms of investigating crime. For example, the growth in cloud computing has meant that there's an increasing need for police to be able to access information that is available only on the internet or via certain apps, and the Act makes that more difficult to carry out than other kinds of searches. We ask if that approach is still justified. Another area in which technology is having an impact is in the area of surveillance. The Act currently permits warrants for some types of surveillance devices, but not for others. This creates uncertainty and leaves a gap in terms of being clear about what the police can and cannot do. These are just two of the examples of the questions that we are raising. And in every case, when we raise a question, we pay attention to the very important balance between law enforcement needs and individual rights that the Act set out to reflect. We'd like to know what you think about the potential problems we've laid out and the choices that might exist to solve those. Your views will help us when we come to make recommendations in the final report that we need to deliver to the Minister of Justice by the end of June 2017, and which the Minister must then make available to Parliament. You can make a submission through our online survey or by mail or post using the addresses on screen.